Check. Hi everyone, good morning. Sandhya, you might want to shift one and use it here. Sorry, what do you want to say? Sandhya might want to shift one. Yeah. You shift and use Sandhya, you want to move here? Yeah. You want to? Good morning, everyone. Thank you all for joining. Good afternoon, actually, exactly. Thank you all for joining this panel with four esteemed lawyers. And just to kind of set context here, we would try to keep it in as simple language as possible. Just to get a sense check, I'm assuming, are there any lawyers in the audience, or are you all? Oh, okay, there are three lawyers. For the rest of you, we'll keep it, as in a simple language that even non-legal folks would understand. And of course, if you have any questions, we'll have 10, 15 minutes in the end to drop our questions. And if you want to catch us after the session as well, feel free to, sorry, I'm offering this without asking you guys, but feel free to catch any of us, yeah? Just to get it going, I think a round of introductions would be great. My name is Akash. I head gaming at Tulsea. So Tulsi's been behind some of the most successful shows like Sacred Games, Made in Heaven, Mirzapur, Patal Lok, recently Kohra, Black Warrant, and many more. In gaming, we help developers get funded, we help them get published. So a couple of games we're involved with are games like Age of Bharat. We helped get Amish Tripathi on board that with Amitabh Bachchan as well. We are also involved with Mukti, which is greenlit by PlayStation, and we help with creative talents on that as well. Primarily, we help developers with whatever they need in whichever field possible. And I'll give it over to Anuradha to introduce herself, and then we can go with a quick round of introductions and go from there.
Hi everyone, my name is Anuradha Chowdhary. I'm the founder of 023 Collective. We're a specialized law firm for new technologies. So we work with clients, of course, in gaming, but also in ed tech and blockchain and AI and deep tech. I'm also on the board of directors of the Blockchain Game Alliance, which is a blockchain gaming international alliance. And I am a trained filmmaker.
Hi everyone, good afternoon. My name is Sandhya Surendran. I run a small boutique practice called Lexic in Bangalore. My focus is media, entertainment and tech. So I primarily do a lot of music related work, which has been very interesting. Happy to be here.
Hi everyone, my name is Siddharth. I am a partner at Poovayya and Company. We're a small law firm. I head the corporate advisory team at Poovayya. So I'm a general corporate lawyer mainly, but I do have an interest and a focus in gaming as well. And personally, I'm also a gamer. So I'm here largely because of personal interest, but also because of professional interest. We do represent a lot of gaming companies as well, but yeah, also here for the conference.
Thank you. I have no idea why they emphasized in a small practice, because I can tell you this is their peer. They're all doing exceptionally well there. Not from a small law firm. I work with Shardul Amarchand. I'm a partner there leading the technology, media and gaming practice. I would want to believe that I'm young enough, but still I think I'm a little bit of a veteran in this space. So I've been around for the last 18 years working for a lot of gaming clients at the intersection of technology, media, content, and just gaming in general. So we do a lot of publishing deals, work with a lot of folks who are in this room, and a lot of the OG gaming companies as well. A lot of them you're familiar with as well. Would be happy to share some of that experience as a takeaway today as well.
Thank you. Um, just, I know how hard the lawyer's work is because we work with several lawyers as well, and I feel honored to be a part of this panel with you guys. To begin with, let's just kind of talk about what an IP is. It's such a misused term. I think it's so widely used, and a lot of people I think also use it without knowing the full context. Just I think Ranjana and I were discussing earlier that when we were walking around, there's so many booths that are doing mythology content, and mythology. Technically, Indian mythology is public domain, but the takes on it could obviously constitute as an IP. But would love to understand from you guys, what do you guys, according to you guys, what is an IP? What is the most misused part of it, and what should these guys know about an IP? Anyone, whoever wants to go.
So I think, I mean, this is what we were also discussing earlier, that when we talk about IP in the context of law, we're talking about intellectual property. And when we talk about IP in the context of content creation, we're talking about a particular project, right? So that itself, that basic distinction itself, I think we need to like set that while we're having this conversation today. So what we are going to be talking about in terms of intellectual property in the gaming space can be divided into multiple things. You have different contexts and concepts called copyright and trademark. So each of those, I think, concepts in intellectual property apply to different aspects of a game, whether it's the design, whether it's the music, whether it's the character or the overall story. And I think, Ranjana, you were mentioning about that the difference between copyright and trademark, and how when people approach you, they say they want to patent their game. Maybe you could like elaborate on that.
I mean, it's a little inside lawyer joke also we were having, that how many times do we really get the question, can I just patent my product or patent my name? And I think it starts with, the first thing is, how familiar are you with this unknown terrain called intellectual property? Trust me, I'm on the other side of the boat. As much as coding scares me, and it doesn't scare a lot of you, I'm sure the word intellectual property rights scare you as well. But the reality is that the more familiar that you get with it, you truly realize, as the word suggests, it's your property flowing from your intellect. And it's broadly classified under multiple different streams, like Sandhya was mentioning, right? So copyright has a certain function, trademark has a certain function, patent has a certain function. For ease of reference, let's just say patent is the least of your concerns, you're not getting anywhere close to it. Copyright is trademark is pretty much where a lot of your life is going to be centered around, right? So I'll let one of the others really talk about the copyright bit of it, because there are a lot of brains on this panel. But let me touch on something very, very lightly on the trademark part. We often ask, what's in a name, right? And when you ask that phrase, what's in a name, you need to think, what's in a name that's really my property? How can it be my property? And when do I make it my property? That's where we're talking about this whole concept called a trademark. So when you're talking about a trademark, think about the name of the game, the name of your characters, think about the logos that you're going to associate with. What's the timing at which you need to really think about these things? Different people may have a different approach, but here's a pearl of wisdom, and I can assure you there's a lot of gray hair there. You need to think about it at the outset, when you're ideating, when you're sort of closer to talking about it with your investors, etc. Is there a monetary sort of investment from your end? Sure, there is. But it's nothing compared to what you're going to protect in the long run. Very palatable price points that you could really have. Bunch of very good lawyers can guide you through the process. But I think the short message that I want to leave with you is, when you ask that question, what's in a name, think about these various aspects of your game and seek to protect it at the very outset. I'll let anyone who would want to talk about copyright. Whoever.
Maybe I'll just react to something that you said, Ranjana. I completely get where you're coming from in terms of thinking about protection of IP from the very beginning, as when you're starting your development process. But just from my experience of working with studios, developers, etc., when you're starting out, you're also throwing things at the wall and seeing what sticks, right? And sometimes you have great ideas, you have great names, you have great concepts that just don't work. And everybody has limited amount of money, limited amount of resources. There is a process that you have to do in terms of prioritizing things, seeing what is working, and then putting your eggs in that basket. So yes, of course, be conscious of it, but maybe so it's a little bit of a it's not a clear answer, unfortunately. And the problem with lawyers is they will never give you a clear answer. But you have to balance protecting your IP as early as possible with making sure that you're protecting the right IP and you're not wasting money on something that maybe won't work out in the long run. So there is that balancing act you have to do. It's not easy, but that's why you talk to lawyers. Most of us would be happy to give you, free advice on conceptual things like this, to let you at least think about exactly what you need to be thinking about and leave the rest to somebody else.
Hi, everyone. So everyone on the panel made very interesting points, and it is clear that IP needs to be protected from the outset. What IP means to me in the sense of gaming goes beyond these traditional forms of intellectual property in gaming that we've come to know, right? And I think the major thing here is that IP is often underestimated in the gaming world. Sure, you can protect your game, you can protect your trademarks, you can protect the title, you can protect the characters, but I don't know how many people are really thinking about remixing their IP. A classic example of this is Fortnite, right, which was originally a battle player game. But they realized very early on that their their main IP is not in fact their story. I mean, there is hardly a story, but it is the ability to bring in characters from Marvel or bring in characters from Stranger Things or host concerts. So what ultimately happened was they ended up creating a universe. And I think it is this that is underestimated in the IP space. So there's a lot that you can do with IP. Sure, it's great to create your IP from scratch, but you can also cross-license IP. And I know Siddhartha is going to talk about this a little bit later on, but you can also cross-license, you can also remix IP, and I think that's where a lot of commercial benefit lies.
Because you mentioned Fortnite and remixing, a lot of these games, particularly games like Roblox and Minecraft, there's so much user-generated content. There's so much, like modding is such a big part of gaming culture. What do people need to be aware of? If there's user-generated content within a game, is there something that is protectable? Is it something that's publicly available? Is it public domain once that's done? How does that work?
Maybe I'll just start. So there's a classic IP lawyer's answer here, which is that you need anything that somebody else is building on top of your IP is sort of diluting your intellectual property. But honestly, as a a fan of games and as a practitioner who's sort of seen how this works, that's not exactly the right approach. Especially if you look at, I mean, exactly, we were talking about Fortnite, we were talking about other games that have been able to use their user base, enthuse their fan base, make sure that there is fan-generated content, and then monetize that as well. If you're able to make a marketplace and get people to sell skins or whatever it is on that marketplace, you're basically using the enthusiasm of your own fan base to, fine, you give them some money, but you're getting money out of it as well, right? You're taking your platform fee also. So it's IP that is sort of piggybacking on your IP, but as long as two things. One is you're clear in your terms and conditions that the ownership of that IP is either jointly or wholly yours, or jointly owned with the content creator. And you're making sure that your platform is able to monetize that in a way that you're also getting something out of it. I don't see any possible reason why you would not want people to generate IP on top of your IP, which is not usually a classical, the classical way an IP lawyer would look at it. But in the current context, I think it's really a very good way to spread your game and to monetize it in a way that perhaps you don't have the bandwidth to do as well.
I want to make one distinction though. I think when you're thinking about whatever suggestions that we gave here, along with your creative hat, keep your commercial hat on as well. Because what IP is going to do to you, and it doesn't matter what categorization it falls under, is give you a right to monetize and commercialize something that you may be thinking today or not thinking, like Anuradha very correctly said, there's a whole universe that you can sort of create. So what Siddharth gave as an example was about user-generated content, but the other side of it is your game could become a success to a point that other businesses would want to run, say, commercial tournaments, right? Classic examples today out there would be the PUBGs of the world, right? There are enough and more big and small players running tournaments for them. Now, is that something that you should be allowing? Sure. But there is a commercial right that you need to recognize that you could monetize. And that's, in fact, what the pattern is. So I go back to what he mentioned about your terms and conditions. So while your terms and conditions may be quite express about what your user fan base could or couldn't do, but at the same time, articulating and vocalizing that any commercialization done by whoever in the ecosystem needs a specific license from you would go a very long way to prove a right. It's not that the right doesn't exist with you, but it's something spelled out there in your terms and conditions. So that's one takeaway I could say. I'm going to hand it to them.
I think you hit the nail on the head, Ranjana, particularly creative people, because we work with a lot of writers and creators. They're so sensitive about their project and, not like letting people abuse it, for the lack of better words. But then if, there are so many examples like games like City Skylines and Grand Theft Auto where because people were allowed to modify the game and do their own things with it, it became such a bigger success than it would have been.
No, absolutely. In fact, Akash, I'm going to give a interesting parallel example where allowing other businesses also tap into your IP could also mean something significant to you. I'm going to give you an interesting example actually from the RMG world. But when the fantasy sports operators, if you see a Dream 11, a lot of them have their formats very similar to a DraftKings, for example. And with the first mover advantage, what they had an IP protection on was technically the entire format of the game. And that's the copyright protection we're talking about. Your format of your game, the feel, format, look, feel, all of that is protected as your intellectual property. But you make a very conscious choice. If you want the kind of game product that you have, if you see merit in having more in the ecosystem as similarly placed players, and that helps you create a better narrative for a product line, then you might take a different commercial decision on whether to protect your IP or allow others to thrive along with it, right? But I think for most people in this room, because the kind of products that we speak about are more creative in nature in that sense, the idea of always protecting your commercialization rights vis-a-vis other businesses should be of paramount importance. You may want to feel very dispassionately or passionately about it, but us lawyers here see it on an everyday basis, like he said, passionate people coming in and feeling very sort of, embedded with these strong feelings about something going wrong. But at the end of the day, this is something which happens very, very often. And the places and some of the suggestions that we are making is what will kind of pull you out of those kind of situations. So I guess take notes.
Did you have anything to add?
We can go to the...
Okay.
Sorry,
No, I'm good.
Yeah, I want to touch upon the collaboration aspect of it as well, because we all know like a game takes so many people to make. There's so many different departments, and if like most of us, the Indian gaming industry is so nascent, most of us depend on freelancers, or we won't hire a person on a full-time salary when we're building a game. What do people have to keep in mind when they're outsourcing something to a partner? What do people have to keep in mind when they're raising funding from a publisher? We've done a few publishing deals, and I know a publisher, if they come in very early, they would say we want to own the IP. So yeah, particularly those two aspects, like when it comes to a publishing or an investment deal, what do people have to keep in mind? When it comes to outsourcing your work, what do people have to keep in mind?
Well, IP for one. I think the main thing is your intellectual property, right? As you rightly said, if a publisher is coming in and they are funding the development of your game, they will want to own the IP in that game. If a publisher is coming in just to commercialize and help you monetize your game and distribute it, then you will likely, hopefully, own the IP in that game and you will give away certain rights. But when you are engaging someone, whether later on as an employee, when you have a more formal structure, or in the beginning as a consultant, you need to ensure that your contracts with them have very clear IP clauses, which says that in easier terms, hey, I'm paying you X amount of money, which means that the work product that you create will be owned by me. In the event that something comes up in the future in relation to what you've created for me that is not owned by me or it comes into question, then you'll assign all your rights in that to me.
And I think it's also important to like have the distinction between different components of a game, right? So from the development stage, if you're looking at maybe licensing a storyline from someone else, or someone else has written a story and you want to adapt it into a game, there's a different kind of an arrangement over there. So is that a license? Do you then own the IP? And the second component being music itself, because all of these have operate also very differently in terms of how intellectual property works. And if you have an employee working for you versus a contractor working for you, IP works very differently. So having all of that in place and ensuring that, like she rightly mentioned, your contracts are, watertight in terms of assignment and making sure you have those work for hire clauses. And ensuring that if you are adapting third-party IP or someone else's intellectual property, you have the necessary licenses to also monetize that. And this applies across the board, not just copyright. You have trademark, you have brands, everything. So yeah, I think.
Okay, not meaning to mansplain what Sandhya said, but I'll give you a practical place where you can, to allow you to think about this. So suppose, again, the same situation that we were talking about where a publisher is wanting to, is going to fund the game, but they want the IP. Now, as a studio, if you're thinking about it from that perspective, you're saying, okay, fine, I'm going to build the engine and I want to be able to use that engine for my games going forward. So then you can draw that distinction between, say, the underlying IP, that is the engine of the game, and everything else that you built on top of it, so that you keep ownership of, and of course, it's not an easy thing to negotiate these things, but at least conceptually, if you have this in your head, you know that this is something you should be thinking about. That I want to keep ownership of the engine. The rest of it, I will give to the publisher because they funded me. But I want the ability to be able to monetize that part of my IP going forward. So that's a way to think about it. You can separate the engine, you can separate the graphical assets, you can separate the writing, you can separate the music. All of those are separate buckets of IP that you can sort of separate out and have different treatment of. So that's something to just think about.
I just have two super quick points. One, non-IP, because we're talking about a publisher-developer sort of an arrangement. I think one thing that really comes up in your entire development process are clauses around approvals and timings and the manner of taking it.
Milestones as well.
Absolutely. And always critically, it is linked to the monetary payouts or the penalties. And at the end of the day, we're all doing this for the money as well, not just the glory, right? More often than not, these clauses for at least the bigger publishers and all are pretty much standard because they have standard set out approval process. What's super important for you is to understand and familiarize yourself thoroughly. And before you get into the contractual arrangement, where do you see to be the pitfalls in that established process, which you see to be a hindrance in your creative timelines and deliverables being met? Because at the end of the day, you don't want a situation that because of the approval process or the amount of interference that's there, it is ultimately the monetary payment cycles, etc., which are also getting affected. Number two, we've been talking a lot about, the IP and the licensing, etc. Just to contextualize a few things that you're going to see in these clauses, right? And you need to be mindful of. Technically, if you're developing something in a relationship of a publisher and a developer, you're more likely than not an employee, in which case you actually own all the IP to begin with, right? And what you're going to see in these agreements are going to be assignment clauses, licensing clauses, depending on what sort of, relationship you've struck with them. There's a key difference between assignment and license. Assignment equal to ownership. License is equal to the right to use. And this is a very fundamental difference. So think about an accounting book, right? Where would you place your assets of what you own versus your liabilities of when you pay your rental? It's literally like that if I was to break it down, right? And whether it's assignment or license, a couple of things that you'll always see in these clauses. We've been talking a lot about commercializing and creating that universe. But how do you create the universe? You know your specs and your talents, but what you're looking at is what's the market that you're looking at? Is it going to be India? Is it going to be global? So territory and identifying what's the territory for which you're licensing, assigning, you have to spell it out. If you don't spell it out, under the law that's applicable, there may be a default clause. 2, the term for something. Now, if it's an assignment, it's a bulk assignment, you still need to sort of identify that it's in perpetuity, whether it's a license, you need to identify the term. If not, Indian law has a default term of 5 years. If it's subject to other laws, there may be other things that are applicable. So term, territory, mode, medium in terms of where could you exploit. And this happens super regularly in, say, in some of the publisher deals also where, say, the underlying IP, say there's a board game out there. And you're going to adapt that to make your game. And, together you're going to be publishing this game. At the end of the day, there's a term which is going to be attached to it. But there's also going to be a genre and a mode in medium. So you may be allowed on mobile games on app stores, but not allowed in some other way. So what you identify as your modes of distribution, exploitation, etc., super important to make sure that's in your contract, whether it's you're at the receiving end or at the end that you're giving your rights. So just things to kind of bear in mind.
And these are also things to keep in mind when choosing your publisher. So there are publishers who are good with certain territories. A publisher is good with China, good with America. So you choose your partners, carve out territories accordingly. So all these things you have to think through, I think, when you start your game development process itself, and you have to keep in mind. I do also want to clarify, and feel free to correct me if I'm wrong, but there is no market standard for terms like this. It comes down to the negotiation. It comes down to who the lawyer is. So everyone just has to have a very good lawyer and an agent to negotiate these things for them, because there is no market standard, right? It depends, like if you're a lawyer on the publisher side, you'll probably try to negotiate to get the IP. If you're a lawyer on the developer side, you'll probably try to not give up the IP, right? So point being, just make sure you have a good lawyer when you get into these things and get one of these guys to negotiate for you. When it comes to in-game assets, like we touched upon the like modding and people like the skins and stuff like that. Who actually owns them? Because there's a whole marketplace of it, like Counter-Strike skins. I know there's recently an article in where the skin market tanked a bit once they changed the rules a little bit. And if I owned a skin, suddenly the value of my skin has gone quite a bit. But who owns it? If I own the skin, do I have any say on what the value should be, or can I sue the publisher for tweaking the rules due to which my asset value decreased?
So the short answer is that you don't own it. The long answer is that when you look at these in-game assets, whether they're skins or they're NFTs, the ownership of the underlying IP will lie with the developer or the studio. And a lot of these assets are promoted, like if you look at Blanco's Block Party, which is a popular game by Mythical Games, they heavily promote the ownership of Blanco's NFTs as fully ownable. But if you look at the end user license agreements by most of these major studios, you will see that you are actually just getting a license to use this IP. In fact, a lot of these contracts or terms and conditions will say that you don't own the right title and interest to this. So this means that, say, for example, you purchase a Sharky B NFT, which is the Blanco's collaboration with Burberry in 2021, where Burberry wanted to basically promote their new fall collection. It's an excellent branding and marketing strategy. But they wanted to promote their fall collection. They created this limited edition character, Sharky B, and Sharky B could purchase Burberry jetpacks, Burberry shoes, but this does not mean that by virtue of owning this NFT, you now have access to create a real life Burberry jetpack, or you get, physical Burberry shoes along with this. Sure, Burberry and Blancos or Mythical Games can together decide that if you buy this NFT, we will give you a limited edition pair of shoes. But this needs to be contractually agreed upon. And there is massive potential in terms of fan engagement, which I know you're going to speak about later on this as well, where at the BGA, we're actually currently working with Manchester City, which is a football club, where we're educating them on the potential use cases in blockchain gaming. So one of the things that we have been speaking about is using Manchester City football avatars in different video games or having their jerseys as skins. And emphasis on if you're a Manchester City fan, then who would not want to have a Manchester City avatar in their, Fortnite game while they're playing? So it is important to understand that with in-game assets, the ownership hands down lies with the developer unless they specifically pass on rights to you. Read the end user license agreement carefully.
Which they never do.
No one ever does. Only the lawyers do sometimes.
Yeah, just to add, so this is probably a little bit further down the line for a lot of you, but in terms of whenever you're building this functionality into your game, in terms of being able to generate or make user-generated content, being able to share it, so modding tools, a marketplace, all of those things, whenever you're reaching that stage, you should also be thinking about the ownership part. And what everybody does and what you should also do if you're ever coming to that stage is to make sure that there are clear terms in terms of whether they get whether the users who are generating this content get any ownership rights, or if it's just a license, and also in terms of how you're going to monetize it. So it is sort of a natural process in the sense that when you're actually thinking about making these tools, you will also be thinking about the ownership, how you're going to monetize all of that. But just keep it in mind that it's always usually owned by the studio or the developer.
Awesome. We have a couple of minutes before we get into questions. I just want to get into the most polarizing topic in the industry, which is AI and the use of it in games. As lawyers, what do you generally advise on the use of AI? Do you think it's I know there are conflicting opinions on it, but legally speaking, is it okay to use AI? Who owns that content if you use it in games?
Okay, maybe I'll start off and I'll hand over to people. So there are multiple issues. It's not something that we can deal with in a 5-minute conversation, but just a few things to keep in mind. One is the tools that you're using. You need to be very clear about what their terms are in terms of ownership. Because if you're using assets that have been generated by another tool, you need to be very clear that you have ownership of those assets. And a lot of tools don't give you that ownership. So they'll give you the asset finally, but they'll say that this is still owned by me. So tomorrow, if you're getting to the stage where you're going to have investors, you're going to have people doing due diligence on your company and saying, do you have ownership of your game? If you have assets where the ownership is questionable, you're going to have a challenge. So you will have to be very clear about the tools that you're using and the ownership of what you get out of that. And possibly where you can fudge this a little bit is maybe use AI tools in the creative process, but not for the final output. Use it for concepts, use it for to get you to 80% of the way, and then use an actual artist so that your IP ownership is clear.
I think I want to break this question to say that when we say the use of IP by game developers, I think there are various facets for which you use AI, right? What Siddharth just mentioned is a lot to do with your game development process and sort of conceptualization to taking it to market, right? That phase of when you're actually doing the creative bits of it. Use of AI could very well be there for other different facets. So for example, making it more adaptive for, say, people with disabilities to be also compliant with law, to put in audio descriptions or to put in screen readers and other kind of things. Integration of that AI technology is not what we are trying to address here, right? So in our mind, when you're talking about the usage of AI, our suggestions are more in terms of what you do for the creative process itself. I'll let the others actually add because we have paucity of time.
Sorry.
I just want to add that bit about, I mean, we do have interactive games where you use AI in maybe creating ambient music while playing in a particular setup, and how that's created, what are the kind of engines that are working to like incorporate and generate that music. I think that is also, it's a massive gray area because how AI has evolved in the music industry, everyone knows it's just, there's just lawsuits after lawsuits. So what tool you're integrating is also kind of critical to evaluate. So, yeah.
You make a very good point. And there is a lot of use cases with AI in terms of generating content. But AI does have the potential, and it is actually currently revolutionizing this industry, not just in the way that games are created, but also in the way that games are experienced. And widely across the industry, this is a growing phenomena where AI is being used for adaptive gameplay, not in the sense of disabilities, which Ranjana mentioned. That's an excellent use case. But also for analyzing player patterns and adapting games for these patterns. And when one of our clients, Zogar Games, they're in booth E15 and they are demoing their product. Go check it out. But one of the things that they are doing is they are using AI to analyze player behavior and customize the game according to that, which means that the way that the player is playing or the way that a player defeats an enemy, the AI will analyze that and make sure that the next enemy that you come across as a player uses different tactics, which means as players, you also have to get more creative. But some of the legal issues that are attached to this, and the major one which I will speak about very briefly, is privacy, right? Because you are, as a game, collecting private information like the name or the email address attached to the player. But then you're also analyzing their behavior. In some cases, you're also recording their voice and analyzing voice patterns, which could mean that you're collecting biometric data. And Ranjana pointed this out earlier, that you have to be mindful not only about the fact that your game is going to be consumed by Indian players, but also about the fact that if you are looking to extend to other jurisdictions, what are the privacy regulations that would apply? That's all from me.
And children also, right? Like depending on what age, what demographic you're targeting. I think we have a lot more stringent laws applicable to like children's privacy if you have like a client base in the US. So that's just adding on to the privacy factor. Yeah.
Sorry, Akash, just 30 seconds here. I think this entire privacy piece is sort of relevant for the audience here because conscious of the fact that you'll not just be using the information to better your product, but as you go along the way, depending on the shoes that you're filling in, you're going to be sitting on massive amounts of user data yourself, which could be monetized as you go along. Now, you're going to find ways and means of monetizing that as well. But just bear in mind, every use case on whether you could do it, say, as anonymized data or, say, for marketing, anonymized data may not even work for that matter. Every use case, not just for overseas territories, but with the new data protection law in India, you need to go back and check with your lawyers whether it's something that you could truly monetize on. Because the kind of class actions that you could probably face from your users, let alone the reputational laws, is never going to be commensurate to the commercialization that you're going to do with the user data. So just bear in mind, hopefully all of you are going to be in the situation where you're going to have massive amounts of user data to sort of build out and commercialize on from as well.
Thanks. Thank you all for such amazing insights. I think we covered most of it. There were a couple of things we didn't cover, but I think we're running short of time, and we do want to give you guys the chance to ask any questions if you all have any. Just raise your hand if you have any questions.
Hello. Excuse me. If I want to make a game from an existing IP, I'm talking IP that is easily 30 plus years old. Well, how do I know if this IP is still, copyrighted? If I want to utilize it, and it's at this point, it's not like Walt Disney's, fairy tales. It's not, their copyright does not exist, I think, anymore.
What kind of IP would it be? Is it a story? Is it a movie?
So it's a former game IP itself. It was a platformer from a long time ago by Monolith Studios. Games called Claw in specific. The studio itself has shut down after publishing Shadow of War. And it's just, I've been looking for it for, I put in 5 days when I had free time to look into where their IP is. I couldn't find it at all.
My first piece of advice would be in a public forum, be vague about what you're pursuing.
Well, it's an IP I wish for many people to actually make games about.
Got it.
Okay, so there's no clear answer here, but what I would say is be very careful, because this is a classic story in terms of generally over the history of game development, people trying to use what they thought were defunct IPs or IPs where the ownership was, nobody had ownership, because companies don't always die. They come back in various forms. They will go into bankruptcy and somebody else will buy the assets. So it's not a given that just because the studio is dead today, tomorrow it's not going to be able to come back and sue you.
The studio is actually dissolved and remade as WB Games. They are on sale right now. I just don't know.
So the problem is somebody will own that IP somewhere.
Yeah.
So don't.
The thing is, the game is easily over 30 years old. I don't know if the copyrights would.
How long does a game IP, like how long does it last?
Copyright?
So copyright lasts 60 years. I mean, there are two components, but 60 years is the...
So is it safe to assume the game will, 60 years will be...
It's still technically protected under law.
So, I mean,
India,
doesn't it have to be like renewed to be 60 years?
No, let me give an explanation. See, we don't know obviously the history of how the IP rights flew there, but it also depends on what part of the IP are you using. Are you using the story? Are you using the creative? Are you using a visual? Each of those aspects have a 60-year timeline running from a different starting point, right? In most cases, so say it's a story that I have written based on which something's been created, and it's my IP, the timeline starts from post my death. So to begin with, if it's been 30 years in the domain, most likely than not, the copyright protection does subsist. Because to begin with, it's always a 60-year timeline in India. Right? Because of harmonization of laws globally too, they follow a similar pattern. So you should take the similar thumb rule for most other countries. I'm caveating it. But at least in your case, without even getting into the grunt work of it, the moment you say 30 years, or we could say someone somewhere out there does have a right to it. Will they claim it is a separate issue. If you do still want to maybe take the risk and go ahead with it, the one basic thing that you need to provision for in your commercials is that if someone comes to claim for it and you need to make good with a license fee, etc., you need to factor that in your commercial rights. So I mean, that's probably the more practical way of looking at it.
So I have to be prepared to, monetarily compensate for them for that if the case that they try to come and, get me.
So let me give you the worst case scenario, and maybe that'll help you think about it. You spent 2 years, 3 years developing this game. You've commercialized it. It starts making money, and then somebody comes and makes a claim. They'll either stop you completely, or they will claim a chunk of your money. And you need to be okay with either of those scenarios, and only then you should go ahead.
Okay. Also, one more question. If I want to make a game about, the Mahabharata, I know it is basically public at this point, But if, like as a Christian person, will the, Indian government will, end up at my doorstep?
I think that's maybe above our pay grade, honestly.
That's all.
There's a question here. Please.
So I'm from GIS background, like the mapping software used for urban planning and everything. So virtual reality we have been using just for visualization. So what we have done is we have developed few tools to do the analysis as well, bringing the real world coordinates and do. So few patents we have filed. So based on the patent, I've started a small LLP and we have approached few tech giants who are working in this GIS platform. So before they come up for us for any funding, we have did some consultancy projects as well for survival. So filing patents and developing new software we can't sustain. So we have took up few consultancy projects. Now what they're telling us, you have taken up you are doing consultancy work also, so we can't go forward with your application. So should I put a different company for this product, or can I go to investor and ask for funding if I'm doing consultancy as well?
The short answer is yes, you should probably transfer the IP into another. It's just cleaner. We understand where they're coming from in terms of if they're going to put money into an entity which they only want the IP assets. They are not so much interested in your other revenues, etc. Yes, so if you can separate those into a separate entity, you're still making the money, but and that's coming to you. And the IP assets which the investors interested in are in a separate entity. That probably makes sense.
Okay. He normally charges for that advice. Yes.
Hello.
We can hear you.
Yes. Now I am very scared about IP. Whether we have to start develop a game after applying IP.
Okay. So I look at it this way. It really depends on, and this is a classic calculation that anybody will have to do when they're running a business. You always have limited resources. You have to allocate them in the best way possible. It's not always the case that you should go for IP protection and things like that first. You will have to do that on an ongoing basis. What I generally tell my clients is that whenever you have like 20, 25K available to you as cash to do something with, do a trademark filing. Usually for the logo of the game or some aspect of the logo of the game, do a trademark filing. And the other thing you should do is make sure that your contracts are good. So those two things usually should cover you in terms of IP, but it's an ongoing thing. You will always have that question of where should I put my money? It's not going to change until you get funded. So it's an ongoing question, but those two things I would say, your one trademark application and your contracts, those you should focus on.
I'd like to add to what you're saying. Yeah, these are the two places to put your money, but I would first put it in the contracts, because what you're contractually parting with and what you're contractually agreeing upon is very important. With trademarks, Ranjana has covered this quite extensively. But one of the things to factor in is that, yes, apply for your trademark later, but document the use of your trademark. So if you have your logo on invoices with vendors, even if you have Instagram posts up, that all helps your use case. The longer that you have been using your title and logo, the longer that you've been commercially benefiting from that use, it makes your case for trademark registration stronger. So you can wait a while, but make sure you're documenting everything.
I also want to add that, we do have a lot of instances where game developers use existing pop culture icons like either celebrities or movie stars or dialogues from films. Be a little careful when you're incorporating all of that, because there is a concept of IP attached to each of these as well.
Actually, I'm not in that level. I'm minimum level.
No, you could be drawing a character that looks like Amitabh Bachchan or Rajnikant, right? So there are certain restrictions applicable to all of that.
And AI also, I think, might give you something that is already out there based on popular faces. So let's just be careful.
Just one quick thing which we've not spoken about at all. We've spoken about trademarks, copyright, etc. But website, domain names as well. the amount of cyber squatting cases that are there and the kind of money that people want when they've squatted on something that was original, because you have this tendency, you think about trademarks, think about everything else, but somehow the domain name is something that you think late in the day. But that's actually a not too expensive investment to begin and make. And as you go into slightly more mature stages of investment, even publishing, etc., as a part of your diligence, your investor will look at what all did you do, including your domain name. Because they do see it as an area where they may have to pay heavy money later on in life if you've not already sort of, protected that piece of it.
First, we have to apply for trademark. Next, we have to apply for patent. And then next, we have
There's
to...
no patent. Let me be very clear. Okay?
IP.
No, so, okay, again, take a step back. Intellectual property rights is the larger umbrella, which has a million zillion things. The three things that we keep talking about is trademark, copyright, and we spoke about patents as well. Ignore patents for the moment as Indian game developers. If you're in the US, we'll talk a different story. So you focus on copyright, which is really more contractually protected. I'll add one other element that you could be sensible about. Say your storylines, etc. You've been documenting it on your laptops, etc. Make sure that all of that has a timestamp, your name stamp. Push comes to shove, you need one of us over here. We'll use that as proof to show a prior use, okay? So copyright is more straightforward in that sense, just some smart things to do. A trademark is where some of the suggestions that we just mentioned comes in handy. And that's about your brand, your logo, your character names and things like that. So in your mind, just bifurcate that. And domain is also a bunch of what would go along with maybe the trademark umbrella. But that's a different registration that you need to follow.
Unfortunately, we've run out of time, but if you have more questions, I think we'll hang around for 5-10 minutes and you guys can catch up with us.
Thank you.
While we're here, yeah? Catch up with us while we're here. We're just hanging around here. We just have to leave the stage, otherwise we'll get sued. Thank you.